Good morning.
Yes, Counsel.
Good morning, Your Honors. May it please the Court, Chris Foster for the Commonwealth. The Commonwealth here only agreed to a charge concession because the common law, Rule 12, and Judge Weingarten all assured that the defendant would serve concurrent terms of 2.5 years in the House of Correction. When Judge Weingarten revised and revoked this subsequent to accepting this plea and imposing the sentence, he violated the common law, the import of Rule 12, and the separation of powers, in addition to creating a possibility for massive inefficiencies in the courts if this Court adopts Judge Weingarten's view.
Your view, however, isn't expressed in the rules that govern.
Pardon me?
This view isn't expressed in the text of the rules.
Not expressly in the text, but I think there's significant case law that does express this. I think there are two cases directly on point. One is Commonwealth versus Fenton F., which is 442 Mass 31, and Commonwealth versus Goodwin, which is 458 Mass 11. In Commonwealth versus Fenton F., the Commonwealth gave up its right to seek an indictment against a juvenile for first-degree murder, and in exchange agreed to the juvenile pleading delinquent to first-degree murder in exchange for a 15 to 20-year sentence. The judge accepted this and imposed the sentence, and 10 years later, the defendant, on his own motion, filed a motion to revise and revoke, arguing that his counsel was ineffective for failing to file a revise and revoke within the 60-day requirement. And this Court specifically said, quote, as a practical matter, nothing could be done to reduce the defendant's sentence to something below that to which he had agreed. I think essentially the Court was saying that once the trial court had imposed this sentence, that it was final.
So you think that resolves the issue? Somehow we spoke to this very issue in Fenton?
I think so. And also, if there's any question for the Court can also look to Commonwealth versus Goodwin. Although it was in dicta, this Court accepted a statement from Commonwealth versus Christian, which was an appeals court case, and this Court quoted from Christian saying that a trial judge may reject a proffered plea bargain, but if the judge accepts the bargain, the judge is bound to sentence in accordance with its terms.
Right, but in Goodwin, the issue was whether the judge could increase the probationary conditions as opposed to decrease it. So that was the issue that was presented in Goodwin.
Correct, but I think when the Court was citing from Commonwealth versus Christian.
I wrote it, and I didn't mean
Correct.
it. So I don't know that Goodwin's going to be substantial support since I'm still alive, and I will tell you that's not what I intended. But so I haven't looked at Fenton yet, but I don't know that Goodwin is going to help you a good deal since that was not the context of Goodwin.
I agree that's not the context, but it was also dicta. Of course, I would defer to your Honor's
but
writing.
Let me ask you this. Let's just put aside the revise and revoke, okay? You go to the judge and you say, we're prepared to drop a particular count, and we all agree the appropriate recommendation is X. The person pleads guilty pursuant to the recommendation. The judge says, I accept the plea, proceeds to sentencing, learns something at sentencing which suggests that the recommendation is too harsh, and imposes a lesser sentence. Why, under 12b2, what can be, according to 12b2, your recommendation is done with the specific understanding that it is not binding upon the court.
Correct.
So why is this any different?
I think in that situation, if I'm correct, I believe this Court has taken that issue up in Commonwealth versus Dean Gainick, which will be argued next month. I think the difference is that once the Court accepts a plea bargain, and here when a judge accepts a charge concession and accepts a guilty plea, he's accepting this bargain. And I think the requirements that the parties are allowed to rely on this, again, I would direct the Court to Goodwin, to Terrell, and Baglioni, where all of those cases say that once a judge accepts a plea bargain, it has the characteristics of a contract. And in Goodwin, Your Honor wrote that it's essentially certainty, that the spirit of Rule 12c is to ensure certainty for the parties.
I mean, well, there's a big difference, though. If the judge were to increase the sentence, then the judge, under the rules, is obliged to give the defendant the opportunity to withdraw. But the Commonwealth isn't given that opportunity under state law, under federal law. If it was an 11(1)C, I think, then the judge would have to agree to give the sentence. But it seems like you're trying to transform our rule into a federal, I think it's 11C1C plea, which isn't agreed upon, and in federal court you'd be correct. But I don't know that that's our rule.
Correct. I think, though, that this court also shouldn't ignore the practical implications if it allows the court, after accepting a charge concession, to sentence as it sees fit. Although this is a relatively minor charge in this case, I don't think it would be hard to imagine a situation where the Commonwealth indicts someone for first-degree murder, but in exchange for a guarantee that the defendant would serve, for example, 19 to 20 years, would accept a plea to manslaughter.
So is that determinative here? I mean, if there were no charge concessions, would your argument be different if it was simply sentencing on a single charge?
I don't think so. I think when there's no charge concession, but it is a plea agreement under Rule 12b, where there are terms that are negotiated and the court accepts them, I think
clearly there's not a separation of powers issue when there's no charge concession.
Correct. I think that's the difference. I think there's still, it would be violative of several cases saying that the plea bargain has the characteristics of a contract, and just like in Fenton F, the court said that
It has some of the characteristics, but it's not really a contract.
Correct. But saying it has some characteristics of a contract, I think then if you have the charge concession on top of that, in addition to those same problems, you also have a separation of powers problem. Essentially here, Judge Weingarten had signed a tender of plea forms assuring both the Commonwealth and the defendant that he was going to sentence in accordance with the plea agreement.
But you would agree that if the case went to trial, the judge could do whatever he or she felt was appropriate.
Correct, and I think the judge here could have rejected the agreement if he didn't like, and I would ask the court to look at the revise and revoke hearing, page 25, and I think Judge Weingarten highlights an anomaly that I don't think this court should condone. He essentially says that on the day I accepted the plea, my hands were bound. I wasn't allowed to do anything. You both had agreed to all of the terms of the plea. But now that we're here 48 days later, now I can do something different. I think the fact that a court could accept the terms of a plea agreement, being fully aware that they were going to change that, would be very chilling on the Commonwealth from ever seeking to engage in a charge concession, especially with serious cases in Superior Court. I think the fact we can't take that risk that it would be totally at a judge's discretion while taking away the Commonwealth's right to seek the highest charge.
I'm a little confused. I mean, wasn't there some information that was not available at the original plea hearing about the drug certificate? Wasn't there, as I understand it, there was a change from the Commonwealth had initially charged him with, what was it, trafficking in a Class A, which was pills, just undifferentiated pills as to which there wasn't any drug certificate available at the time of the plea agreement. Let me just finish, then you can answer my question. And that it was then at some point amended to a possession with intent as to a Class B, which I understand was Percocet.
Correct.
And it wasn't, at the time of the plea agreement, there wasn't, the drug certificate at least appears not to have been available.
It wasn't, at least it wasn't produced at the plea hearing. What's clear from the record that was explained is the defendant was first charged by complaint with trafficking in Class A. While the Commonwealth was awaiting getting a drug certificate, it amended the charges to possession with intent for Class B. But what happened, and what's clear, and the defendant doesn't dispute this, it's at the plea hearing, page 6 to 7, the defendant, when he's asked whether or not he is submitting to this plea under inducements or promises of any sort, defense counsel then says, yes, I was approached by the prosecutor who said that he had got the drug cert back. He was, essentially the Commonwealth was waiting to see if it was trafficking weight. And it ended up being 27.38 grams. So, of course, well within trafficking between 14 and 28 grams. And the Commonwealth decided that they would bring this to the defense counsel and let him know that we would be seeking an indictment. And the defense counsel agrees to this at the plea hearing, that he was told he would be indicted except for this. So it was a charge concession, which is also reaffirmed at the revised and revoke hearing, which is transcript 2 at page 8, that the Commonwealth explains this whole process of how it got to.
So what connection does that have to the judge's concern about the defendant's self-medication?
I think that poses several problems, making Judge Weingarten in this specific situation his decision to revise and revoke inappropriate. essentially he engaged in an extensive question and answer session with the defendant who wasn't under oath, asking him the purposes why he had 60 Percocets and several bags of marijuana. And the defendant said it was for self-medication purposes. The Commonwealth was not allowed to call any rebuttal witnesses or to even cross-examine the defendant about this. And I think essentially the judge was, first of all, acting as an advocate, and I think he also found the fact that the defendant didn't have the intent to distribute. So I think he was essentially reconsidering the defendant's guilt.
Do we know why the judge, sua sponte, did a revise and revoke? Did the judge give any explanation for doing it?
For doing it sua sponte, if you look at the first couple pages of the revise and revoke hearing, he said that he started thinking that he didn't like the fact that the defendant had agreed to the maximum that he could receive in district court, which was 2.5 years in the House of Correction. But I also think it's important to note that Judge Weingarten essentially forced the Commonwealth into this charge concession and essentially restricted the Commonwealth from seeking a minimum mandatory of 3 years in state prison, instead allowing the defendant under the judge had guaranteed the Commonwealth, besides the common law.
I'm sorry, the judge forced the Commonwealth into this plea agreement?
I think if you look at it, he's retroactively interfering with the plea process. The Commonwealth would not have consented to this charge concession if the defendant wasn't sentenced to concurrent terms of 2.5 years.
But the judge didn't force you to enter this deal.
I think essentially he did, because what he was doing was he was not letting the Commonwealth go ahead with the charges it wanted.
Well, what you're really saying is he deceived you.
He
lulled you.
I wouldn't want to characterize it in any bad faith, but I think retroactively, especially if you look at the transcript, Judge Weingarten says, I know on the date of the plea, my hands were tied. Both the parties agreed to this. But now I have this revise and revoke power under Rule 29. So essentially it seemed like on the day of the plea he knew he didn't like it and was going to call the parties back, which I think is something this court should not condone, because at the very least the Commonwealth in all the districts would be hesitant to enter into pleas with certain judges knowing that they would have this unfettered power.
So I take it what you're saying is that in circumstances like this, if a judge is really dissatisfied or for some reason finds the arrangement or the plea agreement unacceptable, the judge's option is to reject the plea.
Correct.
And say go to trial.
I think especially all the cases explaining that these plea agreements have the characteristics of a contract is because once a judge accepts the plea, all the parties' rights are determined at that point. The Commonwealth is entitled to its conviction and to a guarantee of punishment, and the defendant is entitled to a certainty in sentence. And I think the judge is bound by, all the parties are bound by that.
Are you saying that there are no circumstances in which an agreed-upon sentence in a plea agreement can be modified on a revise and revoke?
I think that's what I'm saying, yes. I think the judge at the time of the plea has the power to reject it. But I think that when especially there's a charge concession, he can only accept it totally or reject it totally. Once he imposes it, then that's it.
And your argument is not based on the rule? It's based on some constitutional separation of powers principle?
Well, there's that, especially for the charge concession, but I think you need only look at the language of Rule 12b, where it's a plea conditioned on an agreement. I don't think there's even an agreement for a judge to accept if he's not going to accept all the terms, especially...
You cite some cases in other jurisdictions, I gather, for your proposition, but they appear to suggest that you can do that, for example, if there's an illegal sentence. So you would agree that those are that's a circumstance.
Oh, correct.
And
yes,
of course, a breach of an agreement to testify.
Correct. I would think if it's things like that, or such like a defendant moved to vacate his guilty plea because of a lack of voluntariness or something along those lines.
But going back to Justice Cordy's question, is it a separation of powers or is it a rules question? Couldn't it be a rules question? Isn't it implicit in Rule 29 that a judge can revise and revoke only what he could have to a sentence, only to a sentence to which he could have imposed initially?
Correct. And I think here, I think it's a mix of the common law, just the language of the rules, and the separation of powers when you're talking specifically charge concessions. But I don't think it's limited to charge concessions. I think it's just, in general, once a judge accepts a plea agreement, that all the parties are bound, regardless of if there's a charge concession. If there's a charge concession, it just means you have the additional considerations of the separation of
Sorry,
powers.
so he accepted the plea agreement before the sentencing hearing?
It all happened at the same time. He did the colloquy and accepted the defendant's plea, found it to be knowing, voluntary, intelligent, and then had signed the form guaranteeing that he was going to sentence in accordance with this plea agreement, and then he sentenced that date.
So you're saying then that that the sentencing hearing essentially is a farce because it's already decided, and in fact the judge is bound by it before the sentencing hearing is. So we should basically say there should be no sentencing hearing then when the judge accepts a plea.
Well, I disagree.
What's the
with
sentencing
that.
hearing for?
I think when a judge accepts a plea bargain, he is required to fulfill all the terms of it. He has the power to either fully accept or fully reject it. And I think that's all his limitations. If there are no further questions, the Commonwealth will rest on its brief. Thank you.
Good morning, Your Honors. My name is Michael Warius, and I represent the defendant Marcos Rodriguez. I'm asking the court today to affirm the trial court's order revising the defendant's sentence under Rule 29.
Isn't it a little troubling, however, where the Commonwealth has, as part of a plea deal, given up its executive power to proceed by indictment on much more serious charges, specifically conditioned on a sentence? The judge accepts sentences and then essentially takes it back and changes it, and the Commonwealth has given up its exclusive power to decide to prosecute on a more serious case. Why isn't that a separation of powers problem?
Well, Your Honors, I don't think it's troubling. I think under Rule 12, the Commonwealth should have known the law. They should have understood under Rule 12 that the sentencing recommendation is just that. It's a recommendation between the parties. It's not their individual recommendations for sentencing are not. It's not a binding condition on the judge.
Well, yeah, it
that
is.
He must sentence.
Doesn't the rule provide for either agreed or unagreed recommendations?
It's I believe that the agreement is on.
No. Doesn't the rule provide for agreed or unagreed recommendations?
Well, that's correct. I mean,
So the unagreed recommendation means the defendant can ask for something less, and the agreed recommendation is that that's the deal.
The Rule 12 itself, though, states that the recommendation is not binding on the Commonwealth's recommendation is not binding. Neither is the defendant's. The defendant can be sentenced to a sentence harsher than he asked for. If that's the case, the rule explicitly.
But the judge has to announce that.
That's correct. It's explicit in Rule 12 for the defendant to be notified that his sentence is going to exceed it and he has a right to withdraw.
But if the judge accepts the recommendation and announces that he is not going to exceed the recommendation, he has to order the agreed upon recommendation, doesn't he? He has to impose that sentence.
Well, in this case, he did impose a sentence at the time.
So how can you revise and revoke something that you could not have originally done in the first place?
Well, I believe that he could have done it in the first place. I believe that they've reached an agreement for a finding, is a guilty finding, that they obtained a substantial benefit in this case. And in that benefit, what they obtained is a conviction. They didn't have to go to a trial and risk the ability of an acquittal.
Well, isn't this going to screw up plea negotiations
I don't believe
fairly
so.
well?
No, I don't believe so, because if we go back to the date of his plea, in a hypothetical situation, what could happen is that if the government chooses to, they can negotiate with the defendant to waive his rights. In this case, there was no negotiated waiver of rights. Other states, and in the federal law itself, they already have explicit in them you're waiving your right to a sentence appeal. You're waiving your right to a reduction of the sentence later. In this case, that's not what happened. In this case, that there was a plea that was agreed to, and under Rule 29, the judge decided to revise and revoke it. And I think that this issue has already been reached by this court, and I know my sister didn't mention it, but in the case of Commonwealth versus Peter Ryschenko, decided by this court in February, this court adopted the fact that a sentence could be revised and revoked under Rule 29 even after it's reached by an agreement. In that case, Mr. Ryschenko and the Commonwealth submitted different pleas, different plea recommendations for a sentence. The judge
But
on
that's
that
an
case,
unagreed recommendation.
No, let me continue, Your Honor. In that case, the judge said, I am going to accept the Commonwealth's position. Mr. Ryschenko agreed to be sentenced by it. He later writes a letter to the judge, which the Commonwealth ends up charging him with intimidation of a witness. In its brief, the Commonwealth argues that Mr. Ryshenko, even though they had reached a plea agreement and the judge had sentenced him according to that agreement that he made in court that day, that he still could have asked for a sentence reduction, and that interpreting his letter that he sent.
Isn't that because under that, in that particular case, the agreement was that the Commonwealth would make a certain recommendation and the defendant would make a different recommendation?
Well, I think that the statute is, I believe, is fairly.
But isn't that what happened in that case?
In that case, it is.
Yeah,
And
okay,
then-
but in this case, the case that's here today, the defendant and the Commonwealth agreed to exactly the same sentence.
Well, in that case, Mr. Ryshenko did agree to the same sentence. If you look at the procedural history of that case, he initially submits a recommendation that is different from the Commonwealth, but he then agrees to that sentence. At that point, he's being sentenced to a particular sentence and found guilty because he's made that agreement, that there is an agreement, that Rule 29 is available as a means for the judiciary to check and balance the executive branch, and also to keep sentences uniform and keep sentences just. And in this case, that's what the Commonwealth wants to stem. They want to stem the power of the judiciary in order to oversee just and uniform sentencing practices.
Well, let me ask you this. Let's assume for a moment in this case you agreed upon recommendation. The Commonwealth agrees to drop the trafficking charges, very high danger potential for your client. They've agreed to drop that. You've agreed on a 2.5-year sentence. You present it to the judge. The judge gives the sentence, and then you file a motion to revise and revoke, saying, well, you'd like to bring more information to the attention of the judge. That didn't happen here, but let's assume that happens, all right? You've now essentially convinced the Commonwealth to waive all of their rights, and now you are asserting a right to essentially undermine the whole essence of the deal. Should you be able to do that?
Yes, you should. There are considerations that need to be brought to the attention of the court, and Rule 29 is similar, in fact, to Rule 30B. In Rule 30B, has already been interpreted to allow a defendant to vacate a plea, even a plea agreement that's reached by a sentence, if justice determines so. The language is identical in Rule 29. It really comes down to whether a judge believes that, because you bring the motion to the judge isn't necessarily going to be allowed. There has to be. You have to show the judge that there is a reason that justice would dictate the sentence be changed. And I think that that would go to a narrow amount of exceptions in the case. And I think that in this case is a little bit different.
I mean, do you think in order for a judge to act on your motion to revise and revoke, it has to be a very special case?
I would. Yes, I would. It would have to.
You're backing out of a contract, essentially.
I wouldn't go so far as agreeing that a contract's ever in place, but I can understand that Your Honor's use that interpretation.
You're backing out of a deal in a way that prejudices the Commonwealth substantially.
That's correct.
Should a judge knowingly participate in that, or does there have to be something really extraordinary that creates a total injustice?
Well, I think that you would have to meet the standard of first coming in within the jurisdictional limits, and then secondly, you'd have to show that at the time of sentencing that there was evidence out there that would show that the sentence that he had was not just, was obtained in an unlawful means.
And is that the case here, that it was the sentence was unjust?
Yes, that is what the judge found. He believed that the sentence was unjust.
And how did he go about finding that?
It was based on his interpretation of the defendant's record.
Something that he had at the time of
something that was available at the time that he was sentenced.
And then he had the defendant come in and he questioned the defendant?
The standard under the cases interpreting Rule 29 isn't whether the judge heard it or knew of it himself. The question is whether these facts existed at the time. So therefore, something.
How did he perceive? I mean, so he brought the defendant in and asked the defendant questions, and to give the Commonwealth an opportunity to question the defendant about his answers, to sort of get to the truth, if you know what I mean?
Well, I don't believe he did, but I think that what was brought to the attention of the court was the different factors that were undertaken at that time, and his belief that the sentence was too harsh, and he.
The Commonwealth provided the opportunity to provide evidence in contradiction to this new information, or this new interpretation?
No, they weren't.
Okay, how's that right? How's that fair? How's that consistent with the rules?
Well, the court, I mean, in other cases interpreting when you're brought into court, the Commonwealth was given notice of the hearing and notice of what the hearing was going to be about.
That happened here?
And that happened here. The Commonwealth did not object to the manner that the hearing was conducted in, and the Commonwealth knew that it was being brought forward to revise and revoke the defendant's sentence.
All right, so the Commonwealth didn't ask the question to the defendant at the hearing?
No, they did not.
Okay. Oh, I didn't know that. So they were fine with the process?
The process was unobjected to. The only objection was that the judge himself did not have the power, or that the factors that were brought forward at the hearing were not sufficient to establish a revocation of the sentence or revision of the sentence in the Rule 29.
But you're, in this case, it was sua sponte by the judge. There was no request by the defendant for the judge to revise and revoke, was there?
No, that's correct. But the judge requested of the parties to.
But I mean, but when a defendant agrees to a recommendation, doesn't that bind the defendant not to request a lower recommendation, either at the sentencing hearing or at a revise and revoke?
No, it does not, because at the time of the plea, the sentence is not final. That Rashenko case is particularly the most recent one, and Duopoulos in the past.
Apart from whether it binds the court, who's, by the way, not a party to this agreement, put aside the judge. The judge wasn't a contracting party, but the defendant was. I mean, it's one thing for a judge to say, fine, you can agree that this is the appropriate sentence. I don't think it is, and I'm the person who ultimately is giving sentence, and I'm going to give the sentence which I believe to be appropriate. I didn't agree to the not. You folks agree that this is the appropriate recommendation, and the defendant agrees not to ask for less, but doesn't bind the judge. But it seems to be a different situation if the defendant is going to say, yeah, I agreed that 2 years is the appropriate recommendation, and I agreed not to ask for less, but I'm going to do so in a motion to revise and revoke, but not at the sentencing hearing. I mean, why would that not release the government from its obligation not to charge the dismissed count?
Well,
not to resurrect it and then charge the defendant with it.
The government in this case, knowing the facts that were available to it, made the decision to negotiate for a guilty plea in district court. They could have chose to indict the case and to move the case into Superior Court. They didn't choose to do that. The government is in a position where the courts in other states have also found, in Kansas, that they're in the best position in this case to know the law, to know what they're bargaining for. And in this case, what they were bargaining for was a guilty plea. The parties made a recommendation for sentencing. The recommendation they made, specifically under Rule 12, was not binding, that the judge had the ultimate authority to sentence. Furthermore, the judge also had an authority within 60 days afterward, in the time limit of Rule 29, to revise and revoke the sentence. That this has been done before. The Commonwealth has argued it before, and their unilateral mistake of law doesn't permit them to the unenforcement of this contract. I think this case is very similar to the Santiago case. And in the Santiago case, the defendant negotiates a plea agreement under his belief that he's eligible for early parole. After he finds out he's not eligible for early parole, he wants to withdraw his plea. The court says, no, your unilateral mistake of the law is not an excuse for you to get out of the contract you've made. And that's what this case comes down to. It comes down to the Commonwealth's unilateral mistake of the law. And they have to bear the burden of their mistake in this case. The defendant in this case made a contract. He performed his contract to the fullest. There's no argument that he breached his contract. In this case, there was no frustration of purpose either. The Commonwealth received a benefit. As the Boley case said in Kansas, the benefit here is that they received a conviction, that they didn't have to go to trial and use their resources and risk the ability to have an acquittal. They were able to obtain a conviction without a trial in this case.
Can the defendant waive the right to seek a revision, a revocation revision?
Yes, I would believe that he could.
As part of the plea agreement?
As part of the plea agreement, if he was advised, I would believe a colloquy by the judge that he has a right to an appeal, he has a right to post-conviction relief. I believe he would be able to waive that right, barring certain limitations, such as ineffective assistance of counsel or unknowing or intelligent waiver.
And if he agrees to waive that right, is that binding on the judge? Because, of course, the judge on his own motion revised and revoked this sentence.
I believe in that case, if he made a knowing, intelligent waiver, I believe it would be binding, barring, like I said.
Binding on the
certain-
judge.
It would be binding in the court. But in this case,
Why is it binding on the judge? He didn't
Well,
sign
no-
on to it, or she didn't sign on to it.
I think in this case, the question is, if you're talking about this in a contractual sense, that you're bargaining with the parties and negotiating a waiver of your right, then you would be bound, I think, to the waiver of your right.
Who's the you?
The defendant in this case.
Okay, but
The judge is not a party to it, but in this case, I think that a judge would interpret that it is binding on the court if he does waive his right, in this case, to rise and
In
vote.
federal court, it is routine.
In federal court, it's part of the
For the
actual
U.S. Attorney's
statute.
Office, wholly apart from 11.1c. Even without an 11.1c plea, in federal court, it's routine when they hold the bargaining power for the defendant to agree not to appeal the sentence and perhaps even not to seek a revise and revoke. That may be a very common agreement, even under an unagreed plea in federal court. Doesn't bind the judge. The judge can still sentence higher or lower. Why is it different here for an unagreed plea?
Well, I think in this case, I'm not saying the judge couldn't later make a revise and revoke. What I'm saying is that the defendant would, in fact, be waiving his right to pursue that relief. In this case, the judge did not, it was not a motion by the defendant. It was taken by the court sua sponte. So I would like to make clear, though, that I believe that the defendant himself would not be able to bring that motion forward later, but the judge sua sponte would be able to. It wouldn't bind the judge in his sentencing discretion, but what it would bind is the relief that would be available to the defendant afterward. But in this case, there's no distinction in the statute, like in federal courts. The defendant did not waive his right to seek any type of post-sentencing relief. He did not himself actually seek it. He honored his agreement with the Commonwealth and performed it fully. And for that reason, I believe that this court should affirm the trial court's order.
Thank you, sir.
Thank you, Your Honor.